examiner to order. Great. For the record, today is January 21st, 2025. It's about 10:07 a.m. My name is Yoshi Kumara. I am a hearing examiner with Laminar Law, whom the city has selected to hold certain land use hearings. Today, we have 2 requests for reasonable use exceptions. I'm going to get started by going through a few procedural items, and then we can move on to the agenda. So first, it is my role today to collect evidence in the form of exhibits and testimony to determine whether the proposals comply with the comprehensive plan, zoning ordinances, critical area or areas ordinances, and the criteria for the approval of a reasonable use exception. For evidence in the form of exhibits, I have reviewed and will admit all the exhibits I received prior to the hearing. And if there are additional exhibits that anyone would like admitted, please let me know when you're testifying. For testimony presented today, typically the order we will follow will be the city will provide an overview of the proposal, along with any recommendations. Then we'll hear from the applicant or applicant representative. And after that, members of the public will have an opportunity to testify. And then finally, following public testimony, we will turn back to the applicant and the city as necessary. And finally, all testimony today will be under oath or affirmation because were my decision to be appealed, the recording of today's hearing, along with the admitted exhibits and my written decision, would serve as the foundation for any such appeal. And with that, Christian, are you back with us?
I'm here in audio.
Okay. Do you need we can get started. I think the city, the city can start their presentation. I don't know if you want to try and take a few moments to get your video working.
Yeah, if the city, I can hear everything and you can hear me. If the city wants to proceed, that works for me. And meanwhile, simultaneously, I'll try to solve this issue.
Okay, great. So the first item on the agenda this morning is RUE24-000010, which is a request for a reasonable use exception to allow for the development of a single-family residence and related improvements that would impact wetland buffer associated with a Category 2 interdunal wetland on an approximately 0.42 acre property located at 463 Ocean Shores Boulevard Northwest. I received and reviewed several exhibits in advance of this hearing. These include the staff report prepared by city staff, the application, a wetland delineation buffer rating and buffer rating report prepared by Agua Tierra, and various notice materials. And I will go ahead and admit those exhibits into the record. And Mr. Reed, you're presenting today?
That is correct.
Great. Let's get you sworn in. Please raise your right hand. Perfect. Do you swear or affirm to tell the truth in the testimony that you give here today?
I do, Your Honor.
Great, and thank you. Can you spell your name for the audio recording and explain your role at the city?
Sure. My name is Marshall Reed, M-A-R-S-H-A-L-L. Last name is Reed, spelled R-E-A-D, and I serve as the lead planner and shoreline administrator for the city of Ocean Shores in these matters.
Great. Thank you, Mr. Reed. You can go ahead and proceed with your presentation.
Okay. So this reasonable use exception was taken in on December 18th, 2024. The purpose is for a reasonable use exception authorizing impacts to a wetland buffer for a single family residence in an R1 single family low density zone. The applicants are Jim and Joel Fine, located at 536 Tootle Park Road in Castle Rock, Washington. The project description is the Jim and Joel Fine. The parcel number of this parcel is 090101802700. That's Division 1, Block R and Lot 27 in Ocean Shores, Washington. Site address is 463 Ocean Shores Boulevard Northwest. This is a 17,874 square foot parcel with a proposal to impact 2,887 square feet. The category of the wetland is category 2. It's an interdunal wetland. The zoning, the existing conditions of this parcel, the zoning is R1. Land use is single family, and it is not located in the shoreline jurisdiction. The surrounding conditions for zoning, north, south, east, and west are all single family. The land use designation, north, south, east, and west, is also single family residential. The current or existing land use to the north is a single family residence. To the south is single family vacant undeveloped land. To the east is single family residential vacant undeveloped land. And to the west is the Pacific Ocean. The subject property addressed at 463 Ocean Shores Boulevard Northwest is located in the northwest corner of Ocean Shores. The closest intersecting road is roughly 300 feet south at Jib Street Northwest. The property is zoned R1 and is in the single family zone. The zone in the immediate vicinity is exclusively single family, and impacting the lot for a single family dwelling would be a permitted use in this district. Notice was sent out for a reasonable use exception application for this parcel, scheduled for Tuesday, January 21st, 2025, to owners within 300 feet of the subject property on January 10th, 2025, as required by the Ocean Shores Municipal Code. Hearing information is also available at the City of Ocean Shores website, and was published in the January 7th and January 9th Daily World newspaper. Excuse me for just one moment. We're going to get rid of my phone ringing here. The staff analysis. The staff has determined that this proposed development project is listed as a permitted use in the defined or as defined in the Ocean Shores Municipal Code. Wetland buffers exist on this parcel and the surrounding parcels, which require an approved application of a reasonable use exception to impact any of these wetland or its associated buffers. The purpose of the RUE is to allow use of the parcel that would be allowed and is in all respects otherwise in accordance with the requirements of all applicable development regulations of the city, provided that all reasonable measures to avoid and minimize impact to any wetland or areas or associated buffers are applied, and the applicant demonstrates that the project has been approved under all federal and state regulatory programs applicable to the project. Any impacts to the wetland buffers must be compensated for through the mitigation measures. Where on-site or off-site mitigation is infeasible, compensatory mitigation may be authorized under Ocean Shores Municipal Code 1902.150B. The standard of review, the process to obtain a RUE shall be the same process and criteria applicable to a conditional use permit. 1752-050, the criteria before any conditional use permit is granted, the hearing examiner must determine the following. The use applied for is either listed in the conditional uses allowed in the district, or it is significantly similar to one or more of the listed uses. The approval of the permit would be substantially consistent with the purpose of the district and applicable provisions of the comprehensive plan, and would not adversely affect other uses and properties in the immediate vicinity. And also that the granting of the permit would not reduce the dimensional requirements of the district. Also, it must be determined that no nuisance to life, limb, or property would develop. The code analysis, the project may be allowed as outlined in Ocean Shores Municipal Code 17-16-020. Permitted uses shall be as follows: A, single family residence, which is this proposal. The criteria for wetland or buffer impact approval, relevant code 1902-090, wetland delineation and protection. The Ocean Shores Municipal Code 1902-090 outlines 5 possible criteria to regulate development activities in wetlands or their associated buffers. Only numbers 1 and 3 would apply to this proposal. The hearing examiner, after reviewing pursuant to 1902-150, would find that no practical alternative exists for design, development, and or use of the property in a manner that would not encroach into a wetland or a buffer. And B, the prohibition would preclude the use of the property that would be otherwise legal under all applicable city development regulations and feasible based on the character and circumstances of the property. So those are the sections that would be applicable. The applicant, I'm going to skip down and summarize. The applicant also has set aside portions of the parcel as natural areas in the addition to natural structural setbacks. This would provide buffer to protect the wetland. Areas of this proposal that would typically be used as yard or landscaping will be maintained as functional buffer. This demonstrates the second priority of wetland development, which is minimization. Section D requires that only the minimum necessary to achieve the purpose shall be allowed, and any impacts that are authorized must be mitigated in accordance with the best available science applicable to the situation. The mitigation strategy and sequencing. Mitigation discussion within this delineation report is limited to a proposed strategy of on-site mitigation measures to avoid, minimize, restore, and mitigate any impacts. Wetland impacts are going to be avoided in its entirety. Wetland buffer impacts do exist and will be entirely mitigated on-site. The mitigation measures sequencing will be measures applied to the project site include prior converted areas clear and fill permit in 93, 177 in 2000, and new development to be concentrated in this previously converted areas. The home footprint is a 3-story residence proposed to limit the land footprint. Buffer averaging is going to be employed in the existing previously converted area, which would exceed proposed development. However, the previously converted area configuration does not fit the proposed development area. And so buffer averaging is proposed to offset the new buffer impact area with preservation of now revegetated PCA buffer. A net gain of restored buffer is proposed. Development site is landward of the common line between the residential lots. Proposed mitigation area is closer to the abutting wetland and shoreline than the proposed impact area, resulting in a net gain of buffer habitat function. Permanent protective buffer fencing and sign to be installed per local code. Delineation fencing that is required to bisect a parcel shall be required to have a 2-rail fence with a minimum of 1 critical area sign facing towards the mitigated or developed portion of the parcel. Each run or section of an isolated or delineated area shall have at least 1 sign placed as previously outlined. The city may opt to modify these approved methods of long-term protection if site conditions or level of compliance dictate. These are to provide the minimum level of protection and would not preclude an owner from implementing more restrictive fencing if required for security or pet containment. Should the hearing examiner approve this development, the planning department recommends conditions as listed in addition to any conditions imposed by the hearing examiner. Number 1, the construction must meet all current planning, zoning, and building construction and fire code requirements. The plan shall include delineation, fencing, and signage that would protect the unmitigated critical areas during and after construction activities are completed. And that concludes the staff report for this proposal.
Great. Thank you, Mr. Reed. I do have one question just to clarify. You mentioned that this is not in the shoreline jurisdiction. I know that in the wetland report, it is analyzed under that. So if you could just clarify for me whether this proposal was analyzed under the shoreline jurisdiction or the critical areas jurisdiction, that would be great.
Yeah, that typically gets crossed out in the delineation. So the wetlands in this particular area, if there's a proposed impact to the wetland itself, a direct wetland impact, then it falls under the shoreline jurisdiction. Consultation with the Department of Ecology has concluded that as long in compliance with our shoreline master program, if the impacts to a wetland or if there are no impacts to the wetland proposed, then it does not fall within the shoreline jurisdiction.
Great, thank you so much. And then Mr. Fromuth, how are we doing? I have some questions for you.
I'm here, but I'm appearing upside down, so I'm just gonna turn off the video if that's okay.
Okay, that's fine.
Sorry, folks. All right,
No problem. So we'll go ahead and get you sworn in. If you can raise
yes,
your right hand, great. Do you swear or affirm to tell the truth in the testimony that you give here today?
I do.
Great, thank you. Can you spell your name for the record and explain your role with this project?
Thank you. Christian Fromuth, Christian. Fromuth, F as in Frank, Romuth. I am a biologist, wetland consultant with Agua Tierra, Land and Water, and I'm participating in 2 hearings today, back to back. One is the current one for the Fine family, and the second one will be for the Crawford family, and for projects in Ocean Shores before the RUE.
Great. Thank you, Mr. Fromuth. So I'm wondering if you can sort of walk me through the proposal and the site plan, if there's any information that the city didn't cover that you would like me to know about that.
Sure.
And I do have some specific questions, but if you can maybe just get started with that, that'd be great.
Yeah, thank you. Um, in the site plan documents, there were two sheets, 2 site plans. Sheet 1 is an existing conditions site plan, and sheet 2 is the proposed conditions overlay. Sheet 1 shows the entire property and is at a zoomed out scale. Sheet 1 shows only the development end, or concentrates on the development end of the property, zooms in. So some of the it's a long, narrow property. So the western end, the ocean word end, is not included in the image on sheet 2, just the impact area and all the notes. I'll start with sheet 1 just as an intro. It calls out, and in the wetland report, there's some supporting documents as well. There's we refer to PCA, prior converted area, and that's a little bit different on this project than your average one in Ocean Shores. There was a prior permitted clearing through the city clearing and grading permit, and that created access road and a wider area for development, and then a cleared area for human use beyond the development that extended all the way to the back of the property. At that time, it was approved, and it impacted both buffer and wetland area. On sheet 1, now I noticed that in the copies of the site plans that I looked at that were posted online with the city, sheet 1 is a little bit harder to read. Did you receive hearing examiner, did you receive hard copy in the mail of a clearer copy?
I did not. I have the one that you're referring to. I understand what you're saying about it being a little hard to read. I think I can manage to sort of read through it.
Sure, I think it's because the air photo isn't the site plan is uses the air photo as an overlay, and that darkens the image.
Yes, but I
The
think I can
western
read everything. Yeah.
Sure. So the western end of the property on the existing conditions or historical conditions was cleared all the way to the back. It was a long, narrow clearing strip, not the full width of the property, just a portion of it. And the that rear part of it, which extends past the common line, past the currently proposed development, is proposed not to be utilized, to allow to remain in native habitat, which native shrubs and vegetation have recolonized the site in the back. So that is, I just wanted to use that as a basic understanding of the overall site. Any questions on that one before I shift to the proposed?
No, go ahead and shift to the proposed one.
All righty. The proposed site plan concentrates development landward, eastward of the common line setback. So it's, and it attempts to concentrate the new impacts within within the prior PCA area. It does not 100% concentrate some of the new proposed development, because of the shape of the house and the configuration of the lot does not extends beyond the PCA on the eastern part of the property. However, there is an abundance of the prior converted area that remains untouched, closer to the wetland resource, higher quality buffer when it's closer to the wetland itself. And in general, when you tally the impact area versus the preserved or mitigation area on site, the PCA area that's not being, the old PCA area that's not being touched is being treated as mitigation area, because the client has, the applicant has the right to develop that area, but they are not. And they're essentially allowing this restored site to, restored condition to remain. So that area of the total area of new impact, proposed new impact area is 2,887 square feet, whereas the proposed mitigation area on site is larger than that, 2,984 square feet. So that's the general gist of the general outline of the proposal. I'll stop there and see if there are any things I need to clarify there.
Yeah, so I have some questions. I think probably more broadly about the sort of how the previously converted area works, because as you know, both this hearing as well as the next thing on the agenda both utilize that prior converted area. And so I'm just sort of wondering if you, I guess, I know you have some provision, you have some sort of, I think, numbered provisions on the site plan that talk about, if the applicant can document that the prior converted area was cleared under a permit, as well as then sort of goes through different ways that that impacts could be calculated. And so I'm wondering if you can just maybe talk me through that, maybe touching on, when you're coming to the conclusion that the project will result in no net loss, is there a point in time that you're considering that? Is that, I guess I just want to get a better understanding of that.
Sure.
Vision. That's great.
Well, the starting point for our research on the PCA area was a review of historical permit documents. Now in the wetland, they were included in the some of the supporting information was included in the RUE application. In the wetland delineation report itself, they appear, there are photographs and a copy of the permit, the original clearing and grading permit. Do you have those?
I do. Yeah, I've looked at those.
Okay, so the square footages, there was a site plan included in the original permit of back in 2002. Was the September 10th, 2002 was the permit date. A site plan was provided, and with dimensions of the proposed clearing and filling area. Let me see here. And then aerial photo history was researched to see what photo dates most closely approximated the clearing, to try and at least provide some confirmation that the clearing did in fact happen. And those are provided here. We've got photos from 2008, 2009, and 2006, all showing a similar clearing footprint as to the proposed clearing footprint in the original, in the permitted clearing and grading permit. The square footages of, so we use that as a foundation along with the square footages that were declared in the, and approved in the clearing permit, overlaid those on the existing conditions site as a base layer, and then overlaid the proposed impacts on top of that as well. The net change was that there was, and I'll give you, oversight those numbers once again, just for clarity. There was 2,984 square feet were originally cleared and graded. The proposed new impact is 2,887 square feet. And the difference is 97 square feet of net gain of on-site buffer via buffer averaging. And that the locations of that buffer averaging are distributed on the site, both in the western end that remains untouched and around the proposed development. And if we switch back to the site plan, sheet 2 on the site plan, there are areas indicated as P1, P2, P3, and M1. M1 is the untouched from prior.
Right.
P1, P2, and P3, the new buffer, the current code extends the buffer all the way to the road, so the entire property is buffer. So areas P1, P2, and P3 were subtracted out. They were not, they're not impact, they're avoided. That's avoidance area there.
Right.
But the total of the, I'm sorry, the total of the M1 area is the 2,984, and that includes that's actually all of the original PCA, and then yeah, I guess I'm starting to repeat things here, but tell me where tell me if there's anything else I can help you out with.
Yeah, I appreciate all of that information. I think so I guess you have determined that with this with the sort of preservation or restoration of the portion of that was previously converted in the back that, or I'm sorry, in the back, in the western portion of the property, that that would result in no net loss of wetland functions for this project.
Yes, that is correct.
Okay.
And that's using the same ratio of 1-to-1 mitigation, a 1-to-1 ratio of impact area to preserved area or restoration mitigation area.
Right. Right.
And in fact, there's well, I think I changed screens, but I think the number was a 97 square feet of net gain of restoration area.
Okay. Okay. And then I have one last question. I think it's sort of about both of these projects when I'm looking at them together. And so if you want to wait and address it after we've talked about the next project, but one question I am sort of struggling with a little bit in my head is project 2 mentions needing to, or I don't know about needing to, but project 2 mentions compensating or mitigating for the historic buffer impacts, and this one doesn't. And I don't know whether there's a specific reason that there's a difference there, or whether it's just a function of sort of how the projects came. I know they're in different areas as well, so but they're both just in front of me today. So I'm just sort of thinking about that in my mind, sort of turning that over in my mind. If you had any insight into that question.
Sure. The distinction between these two projects, there's a one distinction I wanted that's useful between the two projects is this current one, there was only some clearing that occurred, both in clearing and filling, both in buffer and wetland, but no structure was ever placed. On the second project, there was clearing and grading occurred, a structure was placed, but then the structure was just recently demolished and removed. In that process, they over excavated the site in order to remove contaminated material. And the site plan, the site geometry and the proposed conditions of the site created the opportunity to do more on site 2 than site 1 is able to do. So there are some distinctions in with that regard. The second site that we're going to see, the demolition site, we'll refer to it as, has an opportunity to restore some actual wetland on the property, as well as buffer area. So that so it's just an opportunistic thing to do a little bit more on that one because the site provided that opportunity. Does that answer the question?
That does. That's very helpful. Thank you, Mr. Fromuth. And I think, actually, can you just really quickly describe the sort of the condition? So back to site 1 again, back to the hearing that we're in the middle of. Can you describe the conditions of the property, or the conditions of the buffer area?
Sure. The vegetative condition, the
Yeah, that
land
would be great.
cover.
Yes, thank you.
Sure. It's generally what we call there are vegetation classes that are referred to in wetlands and just in ecology in general. There's emergent, which is sort of like rushes and reeds, cattails that grow up through water. There's scrub shrub, which is small woody product plants that are shorter, less than 20 feet. And then there's forested, which is taller than that. This site is the dominant vegetation here is scrub shrub. There's an isolated tree here and there. I think it's a shore pine, maybe a couple of Sitka spruce, but it's dominantly the scrub shrub. And the majority of the site is buffer, drier, non-wetland. If you and you can fight your way into the brush, it's pretty thick, by following predominantly the old driveway line. And then you can reach a point where you're able to discern where the clearing and filling extended all the way to the back of the lot, because it's upland, it's higher elevation, and immediately to your right and left, east and to the west of that fill area, it drops off into wetland area. So the vegetation species within the center part, the buffer area, are largely the same species they're tolerant of both wet and buffer. Especially in ocean shores, we get so much rain and so much mist that really the greatest distinction about in some of these sites between wetland and buffer is the soil type. You dig a soil hole and you get wetland soils that are showing up, not in the buffer. So the vegetation is pretty uniform from a species standpoint. There are some more hydrophytic plant species, water-loving species that do show up in the wetland portion on either side of that fill area. So that's the vegetative cover. Anything else that I could tell you?
No, I think that's it. Thank you so much. I don't have any additional questions for the city or Mr. Fromuth. Is the applicant here or anyone else wishing to testify?
I'm not recognizing an applicant name.
Okay.
Was there one other person online?
There is muted, Paul Russell Chevrier.
Well, Mr. Chevrier, if you want to testify about this, you can raise your hand or come off mute and indicate that. If not, that's also okay.
No comments.
Great.
Your Honor, can I offer a little clarification?
Yes, absolutely, Mr. Reed. Thank you.
So these types of projects in Ocean Shores, where there's previously converted areas, the city has a history of issuing clearing and grading permits based solely on a map that showed where the wetlands were at in Ocean Shores. And if you're very familiar with wetland maps, they're not very accurate. And they were doing these basically over the counter. So if you didn't have a wetland shown touching on a lot, then there was no consideration given for the buffer. And in some cases, a wetland that was like right on a property line could potentially have a 300-foot buffer, and at the time should have impacted the entire lot. But this work was being done over the counter. So we have an inordinate amount of previously converted areas that were being allowed to be cleared and filled and developed with no consideration to the wetland, because it was somebody's determination at the time that there were no wetland impacts on the property. So as these hearings go forward, you'll see this propensity where we do have opportunity for the restoration of buffer and in some cases wetland where it was allowed to be filled. And so the distinction in these two properties is they were done with permits. Had these not been done with permits, then I would have looked at it more like a violation, and I would not give them the opportunity for using that restoration as on-site mitigation. But being as the city did authorize permits in the past, I think it only fair to allow them to use what we authorized as mitigation measures. So that kind of gives you a little bit of a history of why we have all of this previously converted area that was done, with permits. The Department of Ecology gave me an opportunity to come in and clean things up and set things right with the wetland regulations and all of the biologists that you'll be working with going forward. And the planning department have been working diligently to get things back on track and doing proper mitigation through these processes with the end goal of having no net loss. So that's kind of our goal here.
Great. Thank you, Mr. Reed. I appreciate that clarification. So with that, unless Mr. Reed or Mr. Fromuth has anything else, I will go ahead and adjourn this first matter. I intend to issue my decision on this application within 10 business days of the record closing.
Thank you.
Okay. When you're, and then Mr. Reed, are we ready to go for the next one?
Yeah,
Okay,
we sure are.
great.
So this is a very similar application. It is a application for a reasonable use exception, number RUE24-000008, submitted November 15th, 2024. The purpose is to make application for a reasonable use exception to authorize impacts to a wetland buffer for a single family residence in an R6B mobile and manufactured home zone. The applicant is Brian Crawford, located at 56 Blacktail Ridge Lane in Elma, Washington. The project description is Brian Crawford, RUE24-000008, and it's located on parcel number 0955-00000200, and that is Rain Street, Tract 2. Site address is 202 East Rain Street Northeast in Ocean Shores, Washington. And this is a 7,286 square foot parcel with 4,235 square feet of impacts. The zoning is R6B, mobile and manufactured homes. The land use is single family. The shoreline jurisdiction does not pertain in this case. The surrounding conditions for zoning, to the north of this parcel is unincorporated Grace Harbor County. To the south is a R6B single family. And to the east and west are also R6B single family residential. The land use designation to the north is Grace Harbor County unincorporated. To the south, east, and west, we have single family designations for the land use. The existing land use to the north is Grace Harbor County land, vacant, undeveloped. To the south is a single family residence, vacant, undeveloped piece of property. To the east is a single family residence, and to the west is also a single family residence, vacant, unimproved lot. Okay, the background on this property, the subject property located at 202 East Rain Street Northeast is located in the northeast corner of Ocean Shores. The closest intersecting road is roughly 23 feet south at Edgewood Avenue Northeast. The property is zoned R6B, mobile and manufactured. The zoning in the immediate vicinity is exclusively R6B and R1 zoning, and impacting these lots for a single family dwelling is a permitted use in this district. Public notice was sent out for today's hearing to property owners within 300 feet of the subject property on January 10th, as required by Ocean Shores Code, and it was also published in the January 7th and 9th editions of the Daily World newspaper, which is our publication. Staff analysis determined that this proposed development project is listed as a permitted use as defined in Ocean Shores Municipal Code 17-26-020A. And that wetland buffers exist on this parcel and the surrounding parcels, which require an approved application for a reasonable use exception in order to impact any of these wetlands or its associated buffers. The purpose of the RUE is to allow use of the parcel that would be allowed and is in all respects otherwise in accordance with the requirements of all applicable development regulations of the city, provided that all reasonable measures to avoid and minimize impact to any wetland area or its associated buffer are applied. And the applicant demonstrates that the project has been approved under all federal and state regulatory programs applicable to the project. Any impacts to the wetland or wetland buffers must be compensated for through mitigation measures. Where on-site mitigation or off-site mitigation is infeasible, compensatory mitigation may be authorized under Ocean Shores Municipal Code Title 19. Standard of review, the process to obtain a reasonable use exception shall be the same process and criteria applicable to a conditional use permit. And if everybody remembers that from the last one, I'll just kind of summarize. We're basically looking for a project that comes out and would not reduce the dimensional requirements of the district, and no nuisance to life, limb, or property would develop as a result of approving this project. The code analysis, the project would be allowed under 17-26-020. Permitted uses shall be as follows: R6B, mobile and manufactured home. It's also allowable to construct a stick-built home or a conventional built home in these districts. The development would be substantially consistent with the purpose of the district and would not adversely affect other uses and properties in the immediate vicinity. This district is intended for low-density, detached, single-family dwellings in order to assure the maximum of light, air, open space, privacy, and the protection of property values. Other uses should only be allowed if they're compatible with these values and consistent with the overall public interest. Where the proposed use appears consistent with the purpose of the district, the proposed site plan shall conform to all city standards. Approving the application would not reduce the dimensional requirements of the district, and there is no indication that allowing this single-family residence in this zone would create any nuisance to life, limb, or property. Summary of the criteria for a wetland or a buffer impact approval. The relevant code is 1902-090, Wetland Delineation and Protection. The Ocean Shores Municipal Code outlines 5 possible options for mitigation. Only numbers 1 and 3 would apply to this proposal. really quickly, the hearing examiner, after review pursuant to section 1902-150, finds that no practical alternative exists. And I'll skip down to number 3. The proposed development is within the original platted area and the use specified in the original plan of the Ocean Shores community as evidenced by the covenants, conditions, and restrictions attached to the property by the developer upon first sale of the lots, and in all respects otherwise is in accordance with the requirements of all applicable development regulations of the city, provided that all reasonable measures again have been employed to avoid or minimize impact to the wetland or buffer. The Crawford project is located in a zoning district where a single-family residence is designated as a permitted use and would be legal under all applicable city development regulations and feasible based on conditions of the parcel. Down to the mitigation section, all proposed impacts are within prior converted area. The entire parcel, just as a matter of summary, the entire parcel was cleared and developed several years ago, and then the property or the structure that was developed initially was demolished for the construction or siting of a new residence. We're setting to achieve a no net loss of buffer habitat relative to historic buffer loss associated with the original home. Additionally, there are some temporal impacts associated with the project construction that will be mitigated with new buffer habitat designation and plantings. The proposed site redevelopment is within the previously converted area occupied by the previous home and appurtenance features, driveway, yard, porch, landscaping. The proposed impacts occupy a reduced footprint area compared to historic site conditions. Demolition and removal of the prior residence included soils cleanup, excavation, and removal. Soil removal resulted in interception of water table within the footprint of the prior home, and the existing ground surface remains below pre-demolition elevation, and new clean fill will be imported. Currently, the city is requiring the proposal to include a 2-rail fencing. This would be for protection of the remediated area of buffer and or wetland. The city would modify potentially these approved methods of long-term protection if site conditions or level of compliance would dictate. The methods are provided as a minimum level of protection and would not preclude an owner from implementing more restrictive fencing if required for security or pet containment. Should the hearing examiner approve the development, the planning department recommends additions as listed in addition to any conditions imposed by the hearing examiner. Construction of this project must meet all current planning, zoning, building construction, and fire code requirements. And they would craft and execute a wetland buffer mitigation plan that will compensate for impacts to wetland buffer. This plan shall include the delineation fencing as signage is outlined above, and protect the unmitigated critical area during and after construction activities are completed. And that concludes the staff report.
Great. Thank you. Thank you, Mr. Reed. I think you had mentioned that the property was developed and I think maybe Mr. Froma said it was recently demolished. Do you know when the original development occurred?
I believe it was in excess of 30 years ago, because if memory serves correct, I think those houses were there when I first started working with the city in 1994. So it's been there's a series of very old mobile homes that were placed along that stretch of Rain Street. It's called the Rain Street Addition. And so there's a series of those, and I would expect that over the years, this is about the 3rd one that has been redeveloped. The other 2 were not in an area that were identified as wetland or buffer habitat. So those got redeveloped without a reasonable use. But that's kind of the history in this general area.
Okay, great. Thank you. That's all I have for the city for now. And Mr. Frommuth, you're still sworn in as well. So similar to the last one, if you can just walk me through the sort of proposal, the site plan and the proposed site plan as well as the existing conditions, that would be great.
Sure. Thank you. The primary distinction between this project and the previous one is that the most recent disturbance on this property is very fresh. So the habitat and the natural vegetation colonization, revegetation of the site has not occurred. It's still, well, there's some small soft rushes and grasses and things that are coming in, but nothing woody has been established. It's principally still a very open, clear lot. So in the prior converted area is larger than what the proposed new project is, and any surplus area is going to be restored to either wetland or mitigation area because the opportunity exists there. There's not already naturally revegetated material like on the other site. So because it's raw ground, we can come in and plant that with a mitigation plan. The most of the lot is going to be planted to buffer, but the rear portion of the lot, actually the very back of the lot is outside of PCA, and it's contains both wetland and buffer area. The very rear of the lot is wetland area, and the vegetation is well established. There's really no improvements that can be made to that. But as you proceed towards the street, and I'm sorry, I'm on sheet 2.
Yeah.
As you proceed towards the street, you cross out of the wetland and into buffer area, and then that is area labeled as M1, and create and restore wetland habitat. That is going to actually be, oh, I'm sorry, it does 3 things. There's some at the very rear of the lot, there's a strip that is buffer, that's higher ground. Then you come into the lot and there's a bit of a wetland peninsula that crosses the property there. And when I say wetland peninsula, it's because some of that area is undisturbed, and it was not, there was no excavation associated with the demolition. So that strip of wetland will be protected, and that's outside of the PCA, that portion of the wetland. Then you cross into the PCA, and there's the opportunity. We've based on other site forensic information, we found that we estimated that wetland extended into the PCA, so that area, and it's not proposed for development. It's available for mitigation. So we're planting it to wetland species in there. And then you enter the, you proceed further towards the street, and then do you see the buffer fence line labeled with BF?
Yes.
Once you cross the buffer fence, you're into the yard area, and that will not be planted. But the perimeter of the site, both east flank and west flank, there's a narrow strip that's going to be planted to buffer. And then the street frontage portion of the site would also be planted to buffer in the areas that are available surrounding the driveway and the front yard.
Great, thank you. And so just to clarify, so the site plan 2, it shows sort of wetland delineation within the prior converted area, but that's not currently wetland, is that?
It's only wetlands. It actually is today by virtue of being over excavated.
Okay.
It was the over excavation happened roughly, I'm just guessing here, about 2 years or so ago, and they intersected the water table because they had to get the contaminated soil out, and it was a crude implement, an excavator. So they over excavated, and it's now started to colonize with wetland species, the rushes and reeds and things. So that area was in the prior converted area. And so that's going to be refilled. The soil, clean soil is going to be brought back in order to support the new home. And in available areas outside of the new impact area, it will be planted in buffer or wetland accordingly, depending on the soil elevation.
Okay, but this is not wetland. So I guess, you know, when I looked at the site, when I was preparing and looking at the site plans, I just wanted to make sure or clarify that this is not sort of, you know, some of the new development extends into this prior converted area wetland, you know, delineation that you have. And I just wanted to make sure that that wasn't going to have direct impact on the wetland that would require Department of Ecology
Right.
notice.
Right. Understood. Yeah. I think the useful word here is jurisdictional versus non-jurisdictional wetland. Stormwater ponds and drainage ditches are non-jurisdictional. This would also fall into that category because it was just it was a approved. There was a permit for removal, demolition, and removal of the soil, and it's basically in the midst of a construction project. So it's non-jurisdictional. However, to help answer the questions that may come up, we saw the wetland veg there, the emergent veg, the rushes and reeds, knew that that would be a question, so we showed where that edge was. But my map should have clarified and put the word non-jurisdictional, you know, wetland plants colonizing the site.
Okay.
Yeah.
And so then when I'm looking at, I'm on a different, looking at you know, a satellite image, and it sort of shows that there is, you know, vegetation along that western side of the property. Is that in that non-jurisdictional wetland?
The western, oh, no, that's, so that's the neighboring property is intact wetland. And it includes trees. And the trees are, you know, the canopy will overhang the property line and show up on an air photo. But then also there is legitimately on site, there's some wetland vegetation species that are occurring since the excavation.
Okay. Great. And then just once again, for the record here, you determined that the project with this sort of mitigation, the mitigation measures would result in no net loss of wetland functions.
Correct. In fact, a net gain.
Right. Great. That's all the questions I have for you, Mr. Fromuth, and for the city, unless unless either of you have more information you want to present to me, or if we have applicant there or anyone else wishing to testify.
Yeah, Your Honor, I guess for the record, typically I state that both of these projects would be exempt under SEPA due to their status as single-family residential developments. And so I just want to, you know, get that statement into the record that both of these projects are SEPA exempt based on that categorical exemption.
Great. Thank you, Mr. Reed. Appreciate that clarification. And I guess I'll go once again to Mr. Chevrier, if you were wishing to testify about this project.
The only comment I would have had has been clarified would be the elevation level, which was below where it was when the demolition occurred. And you said there's going to be new fill brought in, so that's the only concern I have.
Great. Thank you. And any last thoughts on behalf of the city, Mr. Reed or Mr. Fromuth, on behalf of the applicant?
I think we've got everything out there.
Great.
I have nothing to add. Yeah.
Okay, great. So with that, I will go ahead and adjourn this hearing. And again, I intend to issue a decision within 10 working days. And with that, that's it for today. I hope you all have a great day. Thank you so much, Mr. Reed and Mr. Frommuth, for answering my questions. I really appreciate it.
Yeah,
Take care.
thank you all, and I'll try and solve this video issue before next time.
Thank you. Take care.
Yeah.
Bye.